People still use the phrase phone hacking like it is a rumour or a punchline, but parts of this story were tested in court, with convictions, judgments, and formal statements on the record. In the next few minutes, I will walk you through a clear timeline of what phone hacking meant, what was proven, and what is still only alleged. No drama framing, just court clarity and context. We are doing this in 5 parts. Part 1, what phone hacking actually means in this context. Part 2, the early court-proven facts that first exposed the practice. Part 3, how the scandal expanded and why it led to formal inquiries. Part 4, what later civil cases proved or recorded in judgments and settlements. Part 5, what to do with this information when headlines try to simplify it. 1. What phone hacking means. When people say phone hacking in the UK tabloid context, they are usually talking about voicemail interception. The classic pattern was simple. A journalist or private investigator accessed voicemail messages by exploiting weak security settings, then stories were built from private information that was never intended to be public. 2 quick notes keep this honest and clear. First, a lot of reports about phone hacking blends together 3 things that are not the same. Phone hacking itself, other unlawful information gathering methods, and the legal outcomes that followed years later. Second, being proven in court can mean different things. It can mean a criminal conviction. It can mean a civil judgment after judge reviews evidence. It can also mean a settlement that includes a public apology or admissions, which becomes part of the public record even though it is not a full trial verdict. So our goal is not to relive every headline. Our goal is to track what moved from allegation to record. 2. Early proven facts and the first court outcomes. The phone hacking story did not begin in 2011, but 2011 is when it became impossible for the public to ignore. An early turning point was the conviction of the News of the World royal editor Clive Goodman and private investigator Glenn Mulcair in 2007 in relation to phone hacking. That conviction mattered because it showed the method was real and it involved access to voicemail messages. It also showed that private investigators could play a role in information gathering for tabloid stories. At the time, the public narrative was often framed as a limited scandal, an isolated corner, a few bad actors. But over time, reporting, investigations, and later legal claims challenged that narrower framing. This is where media literacy matters. Early on, the question was not only did hacking happen, the question was how widespread it was, who knew, and what methods were used beyond hacking. 3. The scandal expands and why formal inquiry happened. In 2011, the phone hacking scandal in the United Kingdom expanded dramatically. What had initially appeared to be a contained criminal investigation began to reveal wider patterns inside parts of the press. Public anger intensified. Police investigations continued. Prosecutions moved forward, and political attention escalated. The scale of the controversy ultimately led the UK government to establish a formal public inquiry into the culture, practices, and ethics of the press. That inquiry became widely known as the Leveson Inquiry. This moment is significant because it represents something larger than a single criminal prosecution or one newsroom's misconduct. When a government sets up a public inquiry, it is acknowledging that the issue may be systemic rather than isolated. A public inquiry is designed to gather evidence, hear testimony under oath, build a public record, and examine how institutions operate. In this case, the focus was not just on individual reporters, but on broader questions: how information was obtained, how editorial decisions were made, how power was exercised within media organisations, and whether existing oversight mechanisms were sufficient. It is important to approach this carefully. The inquiry itself was not proof that every allegation ever made about press misconduct was true. A public inquiry does not function as a blanket declaration of guilt across an entire industry. What it does represent, however, is a formal recognition that the concerns were serious and widespread enough to justify national scrutiny. The process created an official record and forced examination of practices that might otherwise have remained opaque. From this point in the timeline, the story divides into 2 distinct lanes that are often blurred together in commentary. The first lane is criminal accountability. This involves police investigations, criminal charges, prosecutions, and, in some cases, convictions. Criminal cases focus on whether specific laws were broken and whether individuals can be proven guilty beyond a reasonable doubt. The second lane is civil accountability. This is where individuals, including public figures, bring lawsuits against publishers for misuse of private information, phone hacking, or related claims. Civil cases operate under different standards of proof and pursue different remedies, such as damages or settlements. In these proceedings, judges assess evidence, legal arguments are tested, and some cases are resolved through negotiated settlements that are formally recorded. Understanding the difference between these two lanes is crucial. Criminal proceedings determine guilt and punishment under criminal law. Civil proceedings address harm between private parties and determine compensation or other remedies. Confusing the two can lead to misunderstandings about what was actually decided, who was held accountable, and under which legal framework those decisions were made. 4. What later civil cases proved or put on record. Now we reach the part many people discuss today, because it connects directly to recent court timelines. December 2023 Mirror Group newspaper's judgment. In December 2023, the High Court delivered a judgment in a case against Mirror Group newspapers that included the Duke of Sussex among several claimants. In the judgment summary, the court addressed misuse of private information and assessed evidence about phone hacking and other unlawful information gathering. The key point for this video is not the celebrity angle. The key point is how a court examines sample articles, evidence, and patterns, and then makes findings. In that judgment, the court awarded Prince Harry damages of £140,600 and found that some of the articles examined were the product of phone hacking or other unlawful information gathering. This is a perfect example of why calm clarity beats hot takes. The court did not treat every claim as equally proven. It tested evidence and produced mixed outcomes, which is normal in real litigation. So what was proven here? Not every rumour on the internet. What was proven in this court process is that unlawful methods were used in relation to some reporting, and the court awarded damages on that basis. January 2025 News Group newspapers settlement and public apology. In January 2025, Prince Harry settled his legal claim against News Group newspapers, the publisher of The Sun and the former publisher of News of the World. The timing was notable because the settlement was reached on the very day the trial was due to begin. That detail alone signals how far the case had progressed. Preparations for a full court hearing were complete, and instead of proceeding before a judge, the parties chose to resolve the dispute privately but formally. It is important to be precise about what a settlement is and what it is not. A settlement is not a trial verdict. There is no judicial finding after weeks of evidence and cross-examination. However, a settlement at this level is not meaningless paperwork either. In this instance, the resolution included a public apology that became part of the official record. Reuters published the text of that apology, in which the publisher offered what was described as a full and unequivocal apology for phone hacking, surveillance, and misuse of private information carried out by journalists and private investigators at the News of the World. The apology also referenced intrusion into the private life of Prince Harry and that of Diana, Princess of Wales. That detail matters because public apologies in legal settlements are carefully negotiated and formally worded. They are not casual remarks. When a publisher agrees to specific language acknowledging phone hacking and related practices, that language enters the public record. It can be cited in future reporting, referenced in commentary, and examined in the broader history of media accountability. People sometimes dismiss settlements as if they mean nothing happened or nothing was tested. That view is too simplistic. A settlement means the parties decided not to risk the uncertainty, cost, and publicity of a full trial. It does not automatically equate to a judicial confirmation of every allegation, but it can still include admissions, apologies, and financial compensation that carry weight. In this case, the agreement included damages as well as the published apology. 5. What this timeline means and how to read future headlines. Now we land the lesson. Phone hacking is not one story. It is a long timeline of methods, investigations, and accountability. If you want to stay grounded, use 3 questions whenever you see a headline. First, is this a claim, an allegation, or a proven finding? Second, what kind of court outcome is being discussed? Conviction, judgment, or settlement? Third, what is the scope? Which publisher, which time period, and which method? Phone hacking is one method. Unlawful information gathering is broader. This is also where your values matter. You do not have to enjoy tabloid culture, and you do not have to hate any public figure to care about the principle here. The principle is that private information should not become a business model, and that accountability should exist when boundaries are crossed. What was proven in court includes early convictions and later civil findings and recorded statements that confirm hacking and other unlawful methods existed in the British tabloid ecosystem and were used in ways that harmed individuals. What is not proven is every viral claim and every sweeping statement made online. Some claims are still being argued in courts. Some are allegations denied by publishers. Your job is to separate what is on record from what is only implied. And that is why we do timelines. If you want more calm court timelines and media literacy breakdowns, subscribe and watch the Clear Timeline and Court Explained playlists, and comment with the next case or claim you want mapped out, one record at a time.